Baik, Assalamualaikum warahmatullahi wabarakatuh. Good morning, students, ladies and gentlemen. Welcome to the Faculty of Law, Universitas Brawijaya. Before proceeding the ceremony, we would like to express our sincere gratitude. The first, the Excellency Head of Law Department, Universitas Brawijaya, Ibu Dr. Sukarmi SHMH. The Honorable Speaker from School of Law at the University of Hong Kong, Dr. Daniel Basco. Welcome to Indonesia, sir. The Honorable Speaker from School of Law at the University of Wollongong, Dr. Armin Alimardani, who join us on Zoom today. Honorable Speaker from Faculty of Law, Universitas Indonesia, Mr. Anugrah Rizky Akbari MSc, and also Dr. Milda Istiqomah from Faculty of Law, Universitas Brawijaya. Honorable lecturers and staffs of Faculty of Law, Universitas Brawijaya, and honorable ladies and gentlemen, the participants of the seminars today. Today is a great honor for me to be standing here and welcome each and every one of you in this event. We proudly present International Seminar of Criminal Law Compartment with the title of Current Issues in Sentencing Policy and Research. Ladies and gentlemen, our next agenda is welcoming an opening speech from Head of Law Department, Faculty of Law, Universitas Brawijaya. Therefore, please welcome Ibu Dr. Sukarmi SHMH. The floor is yours, ma'am.
Thank you. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. I'm sorry, I will speak in Bahasa. I think Mr. Daniel very well in good Bahasa Indonesia. Oke, yang saya hormati para pembicara, baik yang dari dalam maupun dari luar, para peserta yang hadir di ruangan maupun yang berada di forum Zoom. Pertama tentunya marilah kita panjatkan puji syukur kehadirat Allah Subhanahu wa taala yang telah melimpahkan rahmat serta hidayahnya kepada kita semua sehingga kita bisa berkumpul di ruangan ini dalam keadaan sehat walafiat dalam rangka International Seminar Current Issues in Sentencing Policy and Research yang diselenggarakan oleh Kompartemen Hukum Pidana. Berikutnya saya menyampaikan salam hormat dan permohonan maaf tentunya dari Bapak Dekan yang tidak bisa hadir untuk membuka acara ini karena beliau ada kegiatan di luar sehingga mewakilkan kepada saya. Hadirin sekalian yang saya hormati, tentu kegiatan ini adalah hal yang sangat bagus. Sementara kemarin kita tahu bersama bahwa telah diputuskan dan disahkannya RUU KUHP menjadi Undang-Undang Hukum Pidana Indonesia yang mana 100 tahun lebih kita menggunakan KUH pidana produk dari Belanda. Kemarinlah kemudian sejarah mencatat kita telah memiliki undang-undang hukum pidana tersendiri versi Indonesia. Namun demikian kita tahu bersama bahwa kehadiran undang-undang hukum pidana tersebut ternyata tidak selesai. Sampai hari ini masih banyak menyisakan berbagai macam masalah-masalah yang tentunya ini membutuhkan untuk penyelesaian. Sekalipun demikian, hukum positif sudah hadir di negara kita, tapi tidak menutup kemungkinan pasti masih ada masalah-masalah. Seperti contoh yang kita ketahui bersama, ada yang disebut dengan penghinaan kepada presiden, masih menyisakan juga masalah. Kemudian ada juga yang dulu sempat ramai, kemudian sudah masuk di KUH pidana sekarang, yaitu terkait dengan hal-hal yang goib, itu pun juga masih menyisakan masalah, termasuk yang didiskusikan pada pagi hari ini, yaitu terkait dengan pidana mati dan sistem pemidanaannya. Tentu hal ini sangat penting, terutama bagi kalangan akademisi untuk bisa memberikan semacam kritik dan kemudian saran yang sifatnya ada konstruktif dalam rangka untuk memperbaiki hukum yang ada. Pagi hari ini hadir beberapa pembicara, yaitu Mr. Daniel, kemudian juga Mr. Amin dari Wolonggong, kemudian ada Ibu Milda yang dari dalam, kemudian juga Pak Anugrah Rizky, selamat datang. Pak Anugrah lewat Zoom, Pak Daniel sudah hadir di Malang, welcome to Malang and enjoy Malang. Tentunya kami berharap diskusi atau seminar pada pagi hari ini akan menghasilkan hal-hal yang sifatnya adalah sangat konstruktif dalam rangka untuk memberikan masukan kepada pemerintah dan kepada DPR, karena masih terbuka peluang. Kalau kita baca di media-media hari ini sudah mulai banyak yang membicarakan peluang masuknya gugatan ke Mahkamah Konstitusi. Nah, pada pagi hari ini juga tentu nanti akan membicarakan hal-hal yang kiranya apa yang perlu untuk diperbaiki, karena masih membutuhkan tenggang waktu, yaitu masa 3 tahun untuk diberlakukan. Nah, masa 3 tahun bukan waktu yang panjang, tapi adalah pendek untuk tentunya memberikan masa yang disebut dengan transisi untuk penyesuaian dengan undang-undang yang baru. Sembari itulah tentunya masih dibuka kemungkinan untuk terjadinya perubahan-perubahan di beberapa pasal yang ada di dalam KUH pidana tersebut. Tentu kami berharap mudah-mudahan seminar pada pagi hari ini menghasilkan masukan-masukan yang sangat membangun, masukan-masukan yang sangat berarti bagi kepentingan akademik maupun kepentingan praktis di level pemerintahan kita. Untuk itu, atas nama pimpinan tentunya mengucapkan terima kasih dan selamat menjalankan seminar di pagi hari ini, yaitu Malang Desember 7, 2022. Dengan mengucap Bismillahirrahmanirrahim, acara International Seminar Faculty of Law Brawijaya University, Current Issues in Sentencing Policy and Research saya nyatakan dibuka. Terima kasih. Billahi taufik wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Okay, the next agenda that we have today is the commemorative souvenir and certificate handover from the head of Law Department to Dr. Pasco. So we invite both of you to come forward. You may give the applause. All right, thank you. And the main agenda that we have today, the seminar that we have been waiting for, and we are fortunate to have some prominent associate professor and also lecturers of law as the speakers today. And we will be guided by a moderator to lead the discussion today. Moving right along, it is my pleasure to introduce you the moderator. Please welcome Mr. Ladito Risang SHMH. Please give him a big applause.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Good morning, all of the participants. Good morning, all of the participant which in online and the offline platform. Dear all speakers, the Harnable Live audience, online audience, the faculty of University of Brawijaya member, welcome to the international seminar Current Issue in the Sentencing Policy and Research, which held by Faculty of Law, University of Brawijaya. I'm Ladito Risang Bagaskoro, now as your moderators today. I'm very pleased to see you in here and welcome all of you in this seminar. Today's seminar is about current issue in the sentencing policy and research. All of us will change to discuss current issue in the policy and practice, then have experience and learn from the expert about recent research in the area. Today we have 4 speakers and I will give you all of the bio. First of all, welcome Dr. Daniel Pasco. Dr. Pasco is an associate professor in the School of Law in the City University of Hong Kong, and he teaches a few subjects as a criminal procedure, criminal law, and legal research and writing. So it's all your time, your chance to find and explore more about the criminal procedure, criminal law, and legal research. And the second, we have Dr. Armin Ali Mardani. Welcome, Dr. Armin. Dr. Armin will give lectures from the Zoom, and we have Dr. Milda Istiqomah. Dr. Armin Ali Mardani is a lecturer in the School of Law, the University of Wollongong. His interdisciplinary research about interaction of law, technology, science, and philosophy. And the second, Dr. Milda Istiqomah is a lecturer in the Criminal Law Department, the Faculty of Law at University of Brawijaya. And the third, we have Mr. Anugrah Rizky Akbari. Good morning, Bang Kiki. Bang Eki or Anugrah Rizky Akbari is the lecturer in the Department of Criminology, University of Indonesia, and he also the legal expert in the ICGR. Okay, now the main discussion, the main session of our discussion today, we will start with the presentation of from Dr. Daniel Pasco. Dr. Daniel Pasco, time is yours.
Okay, thank you very much, everyone. Thank you very much, Head of School. Thank you very much, Dr. Milda. Thank you very much, Moderator. Welcome, students, and also greetings to the other panelists who we'll see on Zoom shortly. Terima kasih banyak untuk undanganmu untuk mengadakan pidato ini di Universitas Brawijaya, dan mohon maaf kalau saya bicara dalam bahasa Inggris. So this is my first trip to Indonesia since 2018, since before the pandemic, and it's a great pleasure to be back. What I plan to do today is to talk about the draft criminal code, the RKUHP, and in particular its death penalty provisions. Of course, this is particularly timely given that the Indonesian legislature, the DPR, passed the draft criminal code anymore. So it's no longer a draft. It will be the criminal code in 3 years' time. But because there is a delay in the implementation, I will still refer to it in this speech as the RKUHP or the draft. And interestingly, during my last trip to Indonesia in 2018, I was conducting some empirical research on this very issue, including interviewing some prominent lawyers and judges and politicians and NGO staff. Now, can we go to the drafts, please? Okay, within the draft, the implementation of the death penalty is found within Book 1, Buku Satu, General Principles, whereas the death penalty also appears as a punishment for individual crimes in Buku Kedua. And there are three main changes that will be reflected comparing the current situation, the current KUHP with Book 1. And all three of these changes show an effort to balance between abolitionist and retentionist perspectives in Indonesia, purportedly to find the third way, or the Indonesian way of dialogue between two political perspectives. And I must also say that although I've already seen some negative commentary on the new criminal code, I find that these provisions, I'll point out, are positive. And personally, I think it's also important to point out the positive aspects of the new code, at least from a death penalty reductionist perspective. And I mentioned that there are three changes, and the three changes are these. The first change is the recategorization of the death penalty, pidana mati, as its own special punishment, or pidana khusus, to be applied alternatively as a last resort. And we can find that in Articles 67 and 98. Rather than as one of the pidana pokok, or principal punishments, or supplementary punishments, pidana tambahan. And those are found within 65 and 66. In the existing KUHP, of course, the death penalty is outlined, or is categorized as a principal punishment rather than a special punishment. Okay, so in the existing KUHP, as you probably know, the death penalty is categorized alongside imprisonment and fines, for example, in Article 10. However, will this make any difference? Several of Yes, I'll speak a little bit louder. Apologies. Several of the interview sources that I interviewed in 2018 cast doubt on whether this particular change would have any practical effect. Okay, the change from normal punishment, okay, to a special punishment would have any practical effect. The death penalty, after all, is still retained in the criminal code for a wide variety of offences in Book 2, including treason, premeditated murder, robbery, and a variety of drug offences. And the fact is that it has, despite it being a discretionary and a maximum punishment throughout the history of the Indonesian legal system, that hasn't stopped judges from issuing death sentences on a fairly regular basis. So I doubt whether the designation as a special punishment, pidana khusus, will make any difference in practice. Of greater potential significance are the other two changes, okay? And the other two changes are encapsulated by paragraphs 100 and 101, which you can see on the screen there. These are the provision of a new probationary death sentence and the president's ability to reconsider the rejection of clemency 10 years later. So I mentioned, you can see the two operative provisions there on the screen, paragraph 100 and paragraph 101. And perhaps for those listening on Zoom who don't speak Bahasa Indonesia, let me translate those paragraphs. Paragraph 100 says, the judge may impose a death sentence with a probationary period of 10 years by taking into account A, the defendant's remorse and prospects of rehabilitation, and B, the role of the accused in the offence. Subsection 2. The probationary death sentence referred to in paragraph 1 must be included in the court judgment. Subsection 3. The probationary period of 10 years begins one day after the court judgment obtains permanent legal force. Subsection 4. If the prisoner during the probationary period demonstrates commendable attitude and behavior, the death penalty may be changed to life imprisonment by presidential decree after obtaining advice from the Supreme Court. And subsection 5. If the prisoner during the probationary period does not demonstrate commendable attitude and behavior and there is no hope for rehabilitation, then the death sentence can be carried out on the orders of the Attorney General. Article 101 reads in English as follows. If the request for clemency for a death row prisoner has been rejected, but the death penalty has not been carried out for 10 years after the refusal of clemency, other than where the prisoner has escaped, then the death sentence may be changed to life imprisonment by presidential decree. So those are the most important changes, I think, these provisions, 100 and 101. And let me first talk about the origins of these provisions before I go into particular interpretation issues. The research I conducted in Indonesia in 2018, along with my co-author, whose name is Tobias Smith from the United States, concerned the spread of the Chinese concept of suspended death sentences outside of China. And not many people realize that actually this provision, Pasal 100, this proposal for a probationary death sentence actually comes from China originally. Based on the research that we did, archival research, Indonesian policymakers probably first learned about the Chinese system of 2-year suspended death sentences from the 6th UN Congress on the Prevention of Crime and Treatment of Offenders in Caracas, Venezuela in 1980. At that Congress in 1980, there were 74 national delegations. And each of those 74 national delegations, amongst other topics, they covered they shared various means that they mitigate capital punishment and lighten penalties and delay execution. Now, we don't have any firm documentary evidence that at this meeting in 1980, the Chinese delegation shared their experiences of suspended death sentences. But what we do know is that both the Chinese and Indonesian delegations were present at that conference. And we also know, in a coincidence, that it was just the year before, in 1979, that the People's Republic of China had codified their first criminal law. Okay, they did not have a codified criminal law until 1979, and suspended execution featured quite prominently within that 1979 codification. So we're not entirely sure whether the Indonesian policymakers got this idea, firstly, from the 1980 Caracas conference. But what we do know, as a very minimum, is that they did get the idea from China. The people we interviewed confirmed that this idea of a probationary or a conditional death sentence, which first appeared in the 1993 draft, was based upon research on this 1979 criminal law of the People's Republic of China by the Indonesian drafters. And you will have heard of Professor Muladi, who was the head of the drafting team. So he confirmed by interview that they got this idea originally from the Chinese criminal code. And so in other words, we know that this provision, Pasal 100, can trace its lineage directly back to Article 43 of the 1979 Penal Code of the People's Republic of China. And in choosing to adopt this type of idea for the conditional death sentence, Muladi and his co-drafters, they saw the 10-year probationary period as an ideal way to balance abolitionist perspectives in Indonesia with retentionist perspectives. Why did they choose 10 years rather than 5 years or perhaps 2 years, which is in the Chinese law. Well, they chose 10 years purportedly because they believed that 2 years would not be long enough to observe changes in the prisoner's behavior. So they wanted to extend it for 10 years. So that's Article 100. If we go to Article 101, there is no evidence at all to link this to the Chinese law. Okay, so to us, this seems to be an Indonesian, a unique Indonesian policy proposal, invention, which effectively gives prisoners a second chance at clemency. And what this provision originates from is it's a codification of a fairly long-standing principle in Indonesian death penalty cases, whereby if a prisoner had clemency rejected and is sort of languishing on death row for a long time, then the president does not choose to execute the prisoner, at least in the Reformasi or the post-Suharto period. In the post-Suharto era, it seems that some death penalty prisoners, especially those who were convicted of murder, seem to have been long forgotten about or quietly forgotten about after they spent more than 10 years sentenced to death but not executed. Interestingly, this provision, if we were to look for parallels in other laws around the world, this provision resembles the legal position in some Commonwealth countries, whereby the UK's Privy Council has ruled that holding someone on death row for a long period is essentially a cruel and unusual punishment. Okay, so 5 years is the maximum term that the Privy Council has allowed. So if there's any resemblance, it is to that particular rule. But as I mentioned, Section 101 or Article 101 is a purely domestic Indonesian invention or innovation, and it's purportedly designed to prevent double punishment. The two punishments are the time on death row and then execution. Okay, the idea being that you should only be punished once. So that's a little about the origins of these two provisions in the RKUHP. Now I've covered the origins, let me talk a little bit about the interpretation of these provisions in detail based on the final draft. So we go to Article 100, subsection 1, and it says that a judge who passes a death sentence, whether that is at trial or whether that is on appeal, so an appeal judge increasing a sentence to death, may suspend the execution of that sentence for 10 years. And it must be for 10 years. It can't be for a lesser period or a longer period. And the criteria for suspension are in subsections A and B, or subsection 1A and 1B. Now, the word may in subsection 1 is significant. Okay, that suggests that the current type of death sentence with no suspension period will continue to exist alongside the probationary death sentence. So in effect, the legislation creates a new type of offence. Okay, it creates a separate death penalty that will continue alongside the current death penalty with, I suppose, immediate execution. And that is very similar to the Chinese model. The defendants who are going to benefit from this new probationary death sentence are outlined in subsections A and B, and they are two categories of people. They are either defendants who play a secondary role in the offence. Okay, so they are co-defendants who have not had a major part to play in the crime, or they are principal defendants who show strong prospects of rehabilitation at the time of sentencing. If we look at paragraph subsection 1A, okay, rasa penyesalan terdakwa dan harapan untuk memperbaiki diri. Okay, remorse, first of all, that is fairly easy to demonstrate at the time of sentencing. And in fact, it's a normal criteria for sentencing. More remorse, which means more regret over what you've done, then the sentence is lowered. What is more difficult to estimate are the chances of successful rehabilitation, because this involves predicting the future. And for the judge, it involves predicting the future 10 years later. Okay, so does the judge think that this defendant will be able to reform himself or herself, having 10 years to do so? Okay, so that's very difficult to predict future behavior of human beings, of anyone, let alone prisoners, 10 years later. How might the judge do that? Well, one of the ways I suggest the judge might do that is to consider the nature of the offence and whether it amounts to a one-off kind of behaviour in the context of the previous criminal convictions that the prisoner has on his or her record. Now let's assume the probationary death sentence is imposed. Okay, so the judge passes the death sentence and then decides for those reasons to suspend it for 10 years. What happens then? The prisoner's attitude and behavior is then observed by prison officials over 10 years spent in prison. And this 10 years begins as soon as the judge's decision carries permanent legal force. When do we have permanent legal force? Well, this means either when the Supreme Court has rejected the cassation appeal, or when the prisoner has run out of appeals or has run out of time. With its wording, if we go to subsection 3, okay, this suggests that the death row prisoner's final procedural options, namely peninjauan kembali, the reopening procedure of the Supreme Court, or executive clemency or grasi, these continue to take place as the probation period continues to run. Okay, so we have the decision of the judge reaching permanent legal force status, then the 10 years begins. But during the first part of the 10 years, we may have one or more peninjauan kembali, and we also may have a clemency petition decided by the president. In Indonesian law, as you know, both of these don't count as sort of regular appeals. They are extraordinary legal remedies for the defendant. And so then we get to the end of the 10 years in prison. And then we have a second decision that is due. And that decision is whether the probation period has been successful or not, based on the criteria set out in subsection 4. The draft that you see on the screen lists the final decision maker as the president of Indonesia. And the reason that's important is because in previous drafts, including up to, I think, 2016, it was the Minister of Law and Human Rights who was listed as the decision maker, whereas that was changed in 2016 to become the president. We also see the advice of the Supreme Court, the compulsory advice being given to the president. And the reason that is significant is because it begins to resemble very closely grasi, Article 14.1 of the 1945 Constitution. The Supreme Court giving compulsory advice, but the final decision being the president's alone. There's also, I suppose, implied within this subsection 4 that both the Supreme Court and the president are going to receive a report from the prison authorities on the behavior of the prisoners. Because otherwise, how would they know whether the prisoner concerned has conducted himself or herself in a commendable manner over 10 years? One of the ambiguities, though, is what is this commendable attitude and behavior? Commendable attitude and behavior. Sikap dan perbuatan yang terpuji. We don't know how this will be defined. by the prison authorities, by the Supreme Court, by the president. Interestingly, in China, where I mentioned this probationary death sentence comes from, the bar to establish this kind of thing is actually very low. So all the prisoner needs to do to have the death sentence permanently mitigated to life imprisonment is to not commit a felony while in prison during the 2 years. Okay, so long as you are not convicted of a serious crime during the probation period, then I suppose there's actually no decision to be made. In the Chinese context, the death sentence automatically converts to a life sentence. And because of that, about 99% of suspended death sentences do not result in execution in China. The other interesting feature of these provisions, the probationary death sentence provisions, is the subtle differences between 100 subsection 4 and 100 subsection 5. Okay, you can see there are small differences between these provisions. And if we interpret the legislation such that the differences were deliberate, okay, we recognize that the difference between the two were deliberate and we're meant to give them effect somehow, there will be some cases where, despite the prisoner behaving quite poorly during the probation period, during the 10 years, there still remains some prospects of rehabilitation. And so long as these prospects exist, the Attorney General cannot enforce the death sentence. So this type of prisoner actually becomes trapped in a sort of procedural limbo. No clemency, of course, no sentence conversion, but also no execution. They remain on death row indefinitely, forever, subject to the next section, which is section 101. So let's go now to 101. And this is a second means of avoiding execution within the RKUHP, and it might be more appropriately labeled as a second chance at clemency. A second chance at clemency from the president. Now, it purportedly applies to cases where the death penalty is suspended or is not suspended. So it applies to both types of cases. And if the death penalty is not executed for 10 years for any reason other than escape, then the president may alter the sentence to life imprisonment. So what it does is that section 101 provides the prisoner with a lifeline after clemency has been rejected. But interestingly, some of the people I interviewed in 2018, their opinion on the origins of this provision, whereas stated that it was a concession to humanity rather than an incentive for the prisoner to rehabilitate himself or herself. It was a concession to what we call the death row syndrome, that is the cruelty of remaining sentenced to death for 10 years or more, not knowing which day you will be executed, rather than the previous article, section 100, which aims very clearly at incentivizing good behavior in prison. And I mentioned that it could apply to the probationary death sentences and the non-probationary death sentences, although clearly it is mainly aimed at the non-probationary death sentences. And interestingly, because I think it can cover both types of situations, it is an open question whether this Article 101 can apply to the current prisoners, so retrospectively, or only to the new prisoners who were sentenced to death after this provision goes into effect in 3 years' time. Within the current Indonesian death row, there are quite a lot of prisoners who have been there for more than 10 years. And so if it applies to these people and it's 10 years after their clemency requests have first been rejected, then they will get a second chance at the conversion of the death sentence to life. One of the weaknesses in this provision, Article 101, is that it doesn't provide any criteria. Okay, all it mentions is that the president, and remember there is no consideration from the Supreme Court, all it mentions is that the president can reduce the sentence if he wants to do it. Okay, and criteria are usually important. It gives the prisoner something to aim for. Okay, at least with Section 100, the prisoner knows that he must behave well, okay, to receive a lesser penalty. For Section 101, there are no explicit criteria mentioned. There's also no right to petition the president, as there is with GRACI. Okay, with GRACI, there are also no formal criteria, but at least in the GRACI law of Indonesia, the prisoner gets the chance to formally write a letter to the president to say, these are the reasons, okay, why my death sentence should be reduced to life imprisonment. The 10 years is also significant. Okay, the 10 years for both of these is the sum of 2 presidential terms. Okay, the president can serve 5 years at a time, twice. And that means for both of these cases, you're going to have your decisions made by a new president. Okay, it doesn't matter when you were sentenced, 10 years later, there will be someone new in power. And of course, the new president's policies may be completely different from the old president's policies, whether they benefit prisoners, whether they do not benefit prisoners. Okay, so that also provides some uncertainty in the law. Let me return now to Section 100, okay, the probationary death sentence. Now, in terms of what I think this will do to the death penalty in Indonesia, it is very difficult to predict. The assumption I think that the section makes is that the majority of death sentences will now be suspended for 10 years. Although the judge still has the power to issue an immediate death sentence, the assumption I think it makes is that the majority will now be, they will choose suspension in most cases. What does that do over 10 years? Okay, 10 years obviously provides more opportunity to rehabilitate oneself. Okay, it's good for prisoners. It provides more opportunity to show remorse. It provides an opportunity perhaps for a change of president 10 years later who may have more lenient policies towards death row prisoners. It provides greater opportunities for lobbying. Okay, so for arguments to be made by NGOs or lawyers or even foreign governments, okay, to reduce the penalty. It even provides greater opportunity, and this is not, a legal matter, for escape. Okay, it provides greater opportunity for bribery during these 10 years. However, those are all circumstances where the prisoner might benefit. There are also circumstances where the 10 years might be to the prisoner's detriment. It provides more time for things to go wrong. Okay, I mentioned in the Chinese case that the definition of good behavior is you must not commit a felony in prison. I suppose the longer you spend in prison, the more time there is to commit a felony. Okay, so that's one downside of the 10 years. It also, of course, may exacerbate the death row effect. And the death row effect is this psychological syndrome associated with not knowing when you will die, not knowing whether you will be executed tomorrow or in a year's time or in 20 years' time. Ironically, this was the very reason why Article 101 was drafted. Okay, Article 101 was drafted as a concession to humanity because the Attorney General did not want to leave death row prisoners on death row forever, okay, awaiting an uncertain fate. Instead, it wasn't about rehabilitation. Instead, it was about stopping double punishment. Let me finish by saying that I mentioned that Article 101, there is some uncertainty over whether it will apply to current death row prisoners or only to future death row prisoners. But its wording is very general. And as such, the implication is it could apply to the current prisoners as well as the future prisoners. Less likely, I think, will be Article 100, the previous section, what is less likely is that this could somehow be interpreted retrospectively, okay, to cover people who are on death row right now. How could it do that? Well, potentially you could allow everyone on death row a resentencing hearing. Okay, that is a new trial, I suppose, and the judge has the option to suspend the death penalty for 10 years or to proceed with the immediate death penalty. What's the situation at present? Well, at present, as you probably know, the Attorney General and the President don't seem to show any signs of wanting to execute anybody on death row. But the problem is a change of policy after the next presidential election leaves many prisoners vulnerable to execution. Okay, there is quite a number of prisoners that a future president could execute if he wanted to do that, because they've run out of appeals and gratia. Allowing a judge to retrospectively suspend a death sentence that has already been imposed, perhaps for the balance of the 10-year period after their clemency petition was rejected, would give current prisoners a little bit more breathing space. And it would allow them more time to demonstrate their good behavior, their rehabilitation in prison to the prison authorities. And the reason I suggest this is that obviously it is too late if you are a death penalty abolitionist to change the law. Okay, the law, as we know, yesterday was passed. But what we can do is try to suggest progressive interpretations of the law, especially, which are important, especially when prisoners' lives are at stake. And with that, I'm going to stop there. Thank you for listening.
Give one more applause from Mr. Daniel. Okay, thank you, Mr. Daniel. We already give us lecture about Article 100 and Article 101 about Indonesian new criminal code, fresh from the oven. Okay, next we will hearing the lectures from Dr. Armin and Dr. Milda about artificial intelligence in sentencing, a case for consistency in corruption decision. Please welcome Dr. Armin. Times and screens yours. And next we will continue with Dr. Mida in forum. Thank you. Yeah.
I'll go first. Okay.
Please.
Thank you. Can anyone hear my voice in the Zoom? Just to make sure that my voice is clear enough. Okay. Thank you very much. I would like to share the screen first. So we already heard about Daniel's presentation, and as Daniel and Ladito mentioned that we have new law that enacted yesterday, and it becomes one of the concerns that we have in the Faculty of Law, whether or not the provisions in the new criminal code, including the death penalty provisions, and as well as the sentencing guidelines and the sentencing factors are actually regulated in a proper way. So in the next 30 minutes, and I and Armin from University of Wollongong, Australia, we would like to present about our ongoing research titled Artificial Intelligence in Sentencing, a case for consistency in corruption decisions. So the background of the study is that corruption is a serious impediment to many countries, including Indonesia. And as we know, that corruption has also brought enormous material and financial loss. Several major cases involved state officials related to abuse of authority, which contributed to state financial loss of 4.5 trillion rupiah. And despite there are so many measures that has been taken by the Indonesia's government, like for example, the revisions of anti-corruption law in 2001. However, based on the data reported by Transparency International, Indonesia is ranked 96 out of 180 countries with a score of 38 out of 100 in the year of 2021. So our paper is actually wants to analyze or wants to evaluate whether the sentencing guidelines that has been created by the Supreme Court in the year 2020 for corruption decisions is actually useful to promote a more consistent sentencing outcomes. I will talk about how this guideline is created, and then next Armin will talk about how we can use the artificial intelligence to promote the consistent sentencing outcomes. So apart from the concern that we have that corruption is still one of the main problems that Indonesia has at the moment, we also look at the judicial system performance and sentencing inconsistency in Indonesia. As we know that inconsistency in sentencing, not only in corruption cases, but also in other cases has been a major issue in the Indonesian judicial system. Also, scholars argue that sentencing decision-making in Indonesia remains flawed and has been plagued by corruption, poor decision-making, and government interference. And let me quote what Adrian Bettner argues in the previous paper is that despite the legal reforms implemented after 1998, the lack of legal certainty still is a hallmark of Indonesia's judicial system. He also states that corruption is one of the main reasons that undermine the legal certainty, where judges may impose sentencing decisions only based on monetary incentives instead of legal reasoning and development. Apart from the weaknesses that we mentioned before, we also acknowledge that sentencing process is actually, it's not a simple task. It's a very complex, complicated, and difficult task. And in order to impose a sentencing outcomes, judges need to consider many factors involved. Like, for example, what Daniel has presented before, in order to ask for gracie, there are other circumstances and considerations that we need to evaluate. So I will go into the detail of the criminal punishment guidelines of Article 2 and Article 3 that is issued by the Supreme Court in the year 2020. So what we know as PERMA, Peraturan Mahkamah Agung, the Supreme Court Regulation, number 1, year 2020, on the guidelines, on the sentencing guidelines for criminalizing Article 2 and Article 3 of the corruption offenses. So based on our interview with the researchers, with the policymaker in the Supreme Court, this guideline is actually adopted from the UK sentencing guidelines. And perhaps we could hear from Pak Eki later on from University of Indonesia, how to compare the sentencing guideline that is regulated in the PERMA for corruption cases, and also sentencing guideline that is regulated in the new criminal code. So based on this PERMA, actually there is a similarity between the UK sentencing guidelines and the PERMA. We could see that there is a similar table and matrix that they use, similar categories, the heavy, the most severe one, and etc. But what is interesting in this PERMA or in these guidelines, judges in determining the severity of the crime must consider a few categories. The first one is state financial loss. The second one is the level of guilt of the defendant. And then the third one is the impact and benefits of the offenses. And then the range of the criminal penalties that the judges may choose. And then also aggravating and mitigating circumstances for the defendant. So this is called as 6 phases that judges may follow in order to determine the sentencing outcomes. But also we found that the categories that we analyze in the sentencing guidelines actually taken from the anti-corruption law itself. So we could see that the guideline is actually breaking it down into several elements to achieve a more consistent sentencing outcomes. So let me go into the detail of the phases in the PERMA. There are 6 phases, and I'll go very quick explaining these phases. The phase 1, we could see that the first stage, judges need to choose what are the categories, what are the state financial laws that has been resulted in each offense. Like for example, the most severe category, the value of the state finances or country's economy losses from corruption crimes is more than 100 billion rupiah. So that's the first or the main criteria that the judge needs to choose. How much money or how much financial loss that has been resulted in a corruption. And then if we go into lower categories after the most severe one, the judges could choose the heavy category, which is the country's economy losses from 25 billion rupiah to 100 billion rupiah. And then we could go lower than that. The moderate category, the light category, the most lightweight category. And then we continue with the second stage. So why we have to explain it in detail? Because these are the criteria or the guideline that we can use to set a database that is useful for creating an AI system for sentencing decisions. So the second stage or the second phase, judges needs to choose fault aspect and impact aspect as well as the benefit aspect. We could go into detail if you are interested in reading the guideline. Just please download it because it's already in the internet. But like for example, if it's like high fault aspect, for example, the judges needs to choose whether defendant has the most significant role on the Corruption Crime Act, or whether the defendant did the offense during economic crisis on national scale. So it is categorized as high fault aspect when the defendant did the offense during economic crisis on national scale. And what about the moderate one? The moderate one, if we compare with the high one, what is categorized as moderate one? When the defendant did the offense during economic crisis on a local scale. So between those categories, between those circumstances, judges need to tick the boxes and then to accumulate all of the points, all of the scores, where I'll go to the next slide because it's too much. And then at the end of the table, the judges need to tick like how many high, how many moderate, and how many low aspects that the defendant has committed in the offense. And then the last one is the judges need to choose one by draw a circle, whether the offenses is categorized as high, moderate, or low. And then I'll go into the last one because I think I don't have much time. Apart from the mathematical or the metrics that they provided in the guidelines, there is also one interesting part that we need to highlight in this guideline, because the guideline also include aggravating and mitigating factors in order to determine the sentencing outcomes, which means that it's not only about mathematical or matrix or table or ticking the box. Judges still has their independency to choose whether any aggravating or mitigating factors that are included. So in the verdict, we can know that as dasar yang memberatkan and dasar yang meringankan. Those are the 3 or 4 lines that we can find at the bottom of the verdict. So what are categorized as aggravating factors? If defendant has committed a crime before, then the judges need to tick. and then the defendant did not cooperate during the investigation, and then the judges need to take that. So everything has to come into the boxes as well, if that exists. And then the mitigating factors, what are the circumstances that are described as mitigating factors? Whether the defendant has never been convicted before, and defendant cooperated during the investigation process, and defendant regret their actions, and that's also a very interesting reason why we have to know whether the defendant regret or not. It's also another question. And whether the defendant has turned themselves in or has reported criminal act that they did. So after calculating all of those factors and then considering the aggravating and mitigating factors, the final phase is another one that we think are very important to highlight, that the judges must consider some additional circumstances, whether the defendant's status is a justice collaborator. So what is justice collaborator? The defendant who working closely with the law enforcement agencies, with the law enforcement officers to reveal another suspect or to reveal another crime. So that's also one of the important reasons where, like, for example, the final sum up is like 15 years imprisonment and 200 billion rupiah as a fine. But when the defendant choose cooperatively as a justice collaborator, then the judges may reduce the sentencing outcomes. So what the guideline tells about it. So we argue that overall, the sentencing guidelines attempts by categorization and breaking down of each sentencing element actually help with the consistency of corruption cases. However, based on our previous research, that we don't have any enough evidence saying that this guideline is actually implemented in all of jurisdictions. So that's also one more thing that we need to evaluate. I will hand in to you, Armin. Thank you.
Hi, can you hear me?
Yes, it's too loud. Yeah, it's too loud. We'll do some adjustment first.
Is it better now?
Yeah, all good. I'll stop the screen first, and time is yours.
Okay, so can you see my screen? I assume you can. Okay, thank you so much. And I'm really sorry I'm not there. I had, teaching commitments at the university, so I couldn't take a flight and come to Indonesia maybe next time. And how much time do I have left?
15 or maximum is 20 minutes, Armin. Thank you.
All right, let's do it. Okay, so I could do it quickly. So as Milda said, we have this guideline for corruption, sentencing corruption cases. And we are considering how we can improve the guideline and whether AI can help us in that regard. So first, we want to say that we don't assume that the guideline is a good thing necessarily. Our assumption is that if it is good, how can we improve it with an AI? So before I get into the details of how it may help, I'll have to explain a little bit what is this AI thing we are talking about. And mainly, I'm going to focus on deep learning. But I just want to give you a brief overview. If you didn't get some parts, don't worry, I never understood them. So I'm kidding. Anyway, so in general, how we do computer programming, a programmer writes rules. If this happened, then do that. If that happened, do that. But when it comes to AI, we usually give the AI data. We give it information and say, go and figure out what are the rules. Okay, so an analogy is that we have a new person in our cafe. We want to teach them how to interact with customers. One way to tell them the rules: if the customer said this, do that. If the other customer said this, do something else. That's the rule. But if I want to give them data, that would be sit here and watch me how I do it for 1 week. And learn how you're supposed to interact with a customer. So I'm not telling them the rules. I'm just giving them data by my behavior. So when it comes, there are many instances that we cannot use the rules because things are too complicated. Like, how do you teach a computer what is a dog? Like, are you going to talk about their ears, their nose, their eyes? Those things all exist in a cat as well. So it would be very difficult. And whether this other dog, the bigger dog, is also a dog. So teaching rules about animals, for instance, animal images, is very difficult. And by the way, these are our pets at home. And so instead, what we do is we give the AI, for instance, 10,000 images of the dogs and ask the AI to learn how to, what is a dog? And then if we give the AI a new image and ask it that whether this is a dog, this is usually what happens. The AI breaks it down into pieces, like we say pixels. And it takes each one of these pixels as input data. So we said we give the AI data, right? And each one of these pixels would have a number, like we give 0 for white pixels, we give 1 for black pixels, and 2 for brown pixels. And that would be our input data. So on the left side, you see these numbers. These are, let's say, different colors. And I wrote like only 4 factors, but of course, there are many more factors here. And like there could be 400 or 1,000. I just couldn't fit them. And then the AI make the calculation and put these numbers and pixels together and see whether, it shapes like an ear of a dog. And then it does another calculation whether it's shaped like a nose of a dog. And at the very end, it gives us some probability based on that 10,000 images that they learned what is a dog. That there's 87% chance that this is a dog. This is an image of a dog. So we give them the data, and they give us the outcome. And this is kind of amazing, and that's how the Google works. For instance, if you search for an animal, but the thing is, these mathematical calculations here, they get so messy that we don't understand how the AI does that. We understand like what are these inputs. We understand there are colors of different pixels, but we don't get it. What happened in the middle that we got here? That's why we call it the black box of AI, if you have ever heard of it. And that's a major problem in what I'm going to discuss about the sentencing. And now you can do the same thing when it comes like to legal matters, like sentencing. Like we have, let's say, 40 different sentencing factors, and we give each one of them a number. For instance, for the amount is stolen, like it was $25, let's say, that's 25, we put it there. If there was no remorse, we put it 0. And what we do is we give the AI 1,000 of previous cases, and also we tell the AI what was the sentence. And the AI considers all these factors and makes calculations and figures out how these factors together interact to get to a specific number. And then we give the AI a new case, and the AI figures out like what are the sentencing factors, and says, okay, I previously saw that how these numbers together, work out, and gives us a prediction that like this for this specific case, probably the sentence would be 12 years. But this is like just an example. It's not that easy, and there are so many other examples that AI being used in legal context. For instance, in Brazil, one of the problems they have is that they have so many cases, they don't know how to deal with them, how to process them. Like 2017, there were 80 million cases that they weren't processed. They didn't even know what are they about. And they use an AI to categorize cases. So AI read all the cases and put them in different categories and make matters much simpler for them. And that reduced 40 minutes of work for each of those cases to 5 seconds, because the AI, it would take 5 seconds for the AI to, say whether it's a civil case, criminal case, it's a political matter, and do the category. In Estonia, soon they will have AI judges, and a judge for minor matters under 7,000 euros. Parties would upload their documents, the AI would read it and make a decision. And if the parties are not happy with the decision, they can appeal to a human judge. Another example is like in Florida, California, and Texas, courts are using AI to fill out the documents. So there are so many documents that have to fill out. It takes time. And they give the documents to an AI. It reads it and understands how to fill out the forms, and put the information in the forms and upload it on the internet. and make things easier. But these are really good examples of nice way of using AI. We have a very controversial one in the US, correctional offender management profiling for alternative sanction tools, which in short we call it COMPAS. And COMPAS, what it does technically, it predicts whether an offender would reoffend in the future once we release them, for instance. And how it works, again, it uses historical data. They use like 10,000 previous cases, and based on 137 factors, that's the input data we talked about, it makes a decision whether, like in the current case, this offender with those characteristics would reoffend in the future, which is a very, very cool thing, okay? But it comes at a cost. There are some problems with it. And one of the major problems is that there are many secrets about how it works. So we have that black box thing. And other than that, we don't know all these 137 questions. What are they? We just know some of them. Like one of them is prior convictions, but we don't know many of them. But other than that, it's been under criticism because of many different reasons. First, the transparency. We have AI black box. We don't know how this AI took that 137, factors and questions in the case, and says at the end that it is very likely this person will reoffend in the future. And the other thing is biases. So it turned out this AI COMPAS is very biased against African Americans. And there was a study in 2016 that suggests that it's very likely African Americans are false positive. That means they're not dangerous, but the system suggests that they are likely to commit an offense in the future. And at first you would be like, yeah, there's a problem with AI, but it turned out it's very likely it's not the problem with AI. It's the data is biased. So we give AI data to learn, how to deal with cases, right? And it turned out it's very likely that courts were considering race as a aggravating factor somehow, and the AI was learning from the judgments, and the AI became like racist somehow. And then the COMPAS developers claim that the race is not one of our 137 questions. But again, it turned out one of the questions apparently is the postcode, and postcode can suggest where do you live and whether you're, for instance, African American or you're white or any other color. So this gets very complicated sometimes. It's not easy to identify, but the system can be biased, and when it's biased and there is no way to object against the outcome because it's not transparent, it's difficult to figure out how the AI make decisions. Then you get stuck. Like the AI says, it's very likely you commit an offense in the future. You can't really, say much against that. And there are two other criticisms. One is the persuasive effect. So if I'm a judge and the AI says this guy is probably, it's very likely they will reoffend in the future, and I'm looking at other evidence that suggests otherwise. But when I consider that, I'm just like, probably the AI is right, and I ignore other evidence available to me. So that's one way that that's one of the other negative matters. The other is the data entry. So we have 137 questions. So people had to go through all the historical cases and enter the information for 137 questions. And many say that that process wasn't done accurately, and we are not sure whether the information they entered, they were all correct or represented the actual case. So these are some of the criticism. And now with all the criticism, why do we think that still Indonesian corruption sentencing guideline can be a good fit for AI? And here is our case. We say, like, let's assume we have 5,000 corruption cases. We collect all 5,000 cases, and we collect all 5,000 guideline judgments that the judges, they filled them out. And we look at each one of them and see, for instance, for the first question, a judge has put a marked here. That means this offender was, involved in the offense most significant. They had most significant role. And AI, by looking at the judgment and how a judge, made a decision, says, okay, in these circumstances, it's their role is, very significant. And for 5,000 cases, it just reviews and learns. And let's imagine we have our AI ready. And if we give our AI a new case or corruption case, it can make a prediction which one of these, boxes they have to check, whether it was the most significant role, whether it was only significant role, or it wasn't a significant role. And there would be, again, the same criticism applied to this AI. First off, we said there's a transparency problem. If you remember, I talked about this black box. And how do we deal with that? So in the guideline sentencing for corruption cases, there's a huge difference with to COMPAS. In COMPAS, we used to take 137 factors and one output at the very end to say whether it's likely this person is gonna reoffend or not, or there is moderate risk, stuff like that. So it was impossible to see how the AI was considering 137 factors. In terms of this guideline judgment and the AI we're talking about, we are creating one AI model for each question. So for this question, we have one AI model. And the AI looks at the case and say, okay, this person had the most significant, role in this case. Can you object to that? Of course, if I'm an offender and there is another offender in the case, a co-offender, and that person had the most significant role, I can show the judge, see in the judgment you have written it, that other person has the most significant, role. So clearly you can object, because unlike the COMPAS with 137 factors, we are looking at matters case by case. And again, we do the same. We have another AI model for the next question and to the end. So that transparency issue wouldn't be as great as we have in COMPAS. And the other is data entry for each factor. So we have to bring people in and say, read the cases, read the judgments, and go and enter information relevant, whether this person, for instance, had a significant role in the judgment. And sometimes it's difficult to say whether this part of the judgment is suggesting this person had a significant role or it didn't. But that's kind of old school. Nowadays, we have natural language processors. It means the AI kind of understands the text. To be very accurate, the AI doesn't understand anything. It's a bunch of 0 and 1. But it feels like as if it's understanding. So just before this session starts, I have access to one of these good AIs, and I wrote this: write a paragraph about sentencing offenders. So if it understands what I'm saying, it can write a paragraph for me. And in less than 2 seconds, it wrote me this paragraph, which is pretty good. So this is what we call natural language processors. It can understand the natural language and it can provide, a feedback to the natural language. And this is if it comes to your mind, I can Google that. This is different from Google. It's not copy pasting. It is actually creating this. This is new. You probably, if you copy this and searching on Google, you won't find this combination of text. This is kind of original work. Anyway, so for any question like this, the AI looks at the case, and because it understands the language somehow, it can figure out automatically what are the matters that are correlated for being involved in a case. And then it says that, yeah, judges that have, selected high when specific matters, are present in a case. So this is how it can learn, and we don't need to do the data entry. We just need to fit the judgment itself to the AI. And that's the case for other factors. The AI can make a correlation. And the next, the last one I'm going to talk about is persuasive effect. So I said, if the AI tells me that this person is likely to reoffend in the future, I may ignore other evidence. And that's true, but what we have in mind in terms of this guideline judgment, it is not as if a judge sees how the AI has predicted all the matters in the case. We will let the judge first make a decision. So if I'm a judge, I say, okay, based on the specific matters in the case, this person had significant role. It wasn't the most significant role, right? And then at that point, the AI comes in and says, okay, I'm going to flag this specific question. I'm going to tell you that your colleagues in very similar cases, 72% of them, they selected high, 18% selected moderate or the significant, and 10% the other one. So it's kind of informing, helping the judge to whether the decision they have made within, consistent with other judges or not. And that's our case. And we say this is how you can increase the consistency. And many of those criticism about other types of AI wouldn't be applied to this. Is my time up? Okay, I thought somebody's talking. So yeah, and at the same time, if I'm a judge, I'm done in like 2-3 minutes. At the same time, if I'm a judge and I'm like, this case is clear, this person only had significant, role. It wasn't most significant. That's how I understand that the data in our judgments are biased. So judges, when it comes to this specific type of cases, for some reason, are selecting this one. Then I can inform the system and say, we are being very consistent here, and there seems to be a bias, and we can correct the system that are sentencing. And yeah, so the last slide is that, but there are still problems with this system. First off, we did some investigation. We realized that it seems none of the judges, or at least we couldn't find any evidence that the judges were using the guideline for sentencing of corruption cases. And if they're not filling out those, guidelines, we don't have data to feed to AI. We wouldn't have any AI. Second, judges generally don't necessarily reflect on all the sentencing matters in their judgment. They may miss some matters. They may find them not important. They may just feel lazy, and don't, write those specific matters. So our AI wouldn't learn, exactly how to relate some of the matters in the case to that outcome that the judge has come up with. And courts could, out of convenience, just escape their decision making and rely on AI. So if I'm a judge, I'm just like struggling with one of the questions. I just like, okay, let me randomly select high for this case and see if the AI gonna pick on me. And if the AI doesn't flag, I'm just like, yeah, I got lucky, and I go to the next one. So we need a system to supervise that if there are some judges abusing it. And finally, if I'm a judge again, I select an option like moderate, and AI flags and says like 90% of your colleagues in similar case are selecting high instead of moderate. Then I might be too lazy just to investigate why. Why is that? I would just say, okay, I will go high, and I don't care about it. So we can't correct the system. If the data is biased, I'm just insisting on it stay biased. I'm just adding to the data that this biased behavior is how it should be, and the AI becomes more and more biased even. And in conclusion, we want to say that it seems to be a good case for Indonesia in terms of corruption cases, considering the guideline judgment, the guideline for sentencing, that they can use AI to improve the consistency to next level. But there are some barriers, including that apparently judges don't fill out the guideline forms, and without those you can't have an AI. So if we could fix those matters, then it would be very likely to have some form of AI. We can't say for sure, but some form of AI that even increase the consistency further. Thank you so much. I'm sorry if I talk too much.
Okay, thank you, Dr. Armin. Thank you, Dr. Mida. Please give the greatest applause from them. Okay, next at the last is Mr. Anugrah Rizky. Will give our lecture to us about sentencing guidelines in the Indonesian US Criminal Code. Mas Rizky, Bang Rizky, ready? Okay, in the next 20 minutes.
Yeah.
Yours, please. Thank you.
Okay, thank you, Mas Nadito. Good morning, everyone. Is my voice clear enough? Because in here there's a lot of noise. I hope my voice is clear enough.
Excuse me, louder, please, Pak Rizky. Okay.
Hello.
Okay, clear.
Is it clear enough?
Yep. Thank you.
Yeah. Okay. Yeah. Thank you all. I'm following up our discussion from Daniel and Milda and Armin. I'm going to talk specifically about the sentencing guidelines in the Indonesian US Criminal Code. As you know, yesterday, the government and the parliament has just passed the new bill on Indonesian Criminal Code, which has been discussed over 2 periods of our parliamentary sessions. And then right now, they're being finalized in order to be able to be published through legislative systems. But bear in mind, everyone, but the Indonesian Criminal Code will give us 3 years of transitional period. So there's a lot of time for us to prepare for the new system, and one of it is the topic that I want to talk about. I want to give you some overview regarding the law itself. So what's new? In my opinion, there's not much, because basically we're trying to just update our current criminal code, and then we're sort of adding and editing some substances, and then put it put it in a new way, in a way that this is a new whole system, but basically it's not that different, because we're trying to upgrade from the current criminal code, which we inherited from the Dutch in the 1980s, and then we're trying to, you know, sort of long adding and editing some features of it. But in terms of sentencing, there's a lot to talk about. Daniel just give us an overview how the new model of our death penalty gives a lot of hope, but also portions of uncertainty in the sphere of our sentencing system. But I'm going to talk about one topic, that is a sentencing guideline. As Milda explained earlier, we only have one particular guideline in our criminal law, which is the sentencing guideline on the corruption cases, specifically for Article 2 and 3 concerning the state corruptions. But what we will have in the next 3 years in our newest criminal code, this is different to other well-known guidelines. I would call this type of guideline as a tick box of sentencing process. So it's not a guidelines in a way that it provides a range of punishments as we already know in the US and the UK system with different perspective. But in here, as you will understand later, there is just a lot of factors of sentencing that judges need to be considered before they imposing a certain sentence to the offenders. But in this guideline, there's a lot of features. The first one, there's the principle that the judges should prefer the value of justice over legal certainty. So this is sort of like a classic Indonesian debates of the sentencing process, and it's heated up because a lot of cases, minor offenses such as a petty theft, the judges just condemn them with sort of like heavier imprisonment. In my opinion, it won't do a lot of changes to the sentencing practices in Indonesia, because the current problem regarding these conflicting ideas, because Indonesian judges did not have any much options in terms of sentencing. As you know, we have in our criminal code, there is a majority punishments in our crimes which will be condemned. It's either imprisonment or also the criminal fine. But the only problem why the judges has to impose the imprisonment as a sanctions, because the Indonesian judges cannot do anything about the criminal fine. We failed to update the monetary value from the 1960s, and it forces the judge to use imprisonment as the only available punishment in their cases. So in terms of the initiative taken in the so-called sentencing guideline in the newest criminal code. The feature number one in here, I believe it won't do such a good changes to the practices in Indonesia. We need some very technical formulations, stipulations that could be practically used by the judges in order to have a better sentencing practices. The second one, we're now trying to dive into the so-called sentencing guideline. So what I said earlier, this is such a tick box of sentencing processes, and it regulates in a way that the Article 51, paragraph 1, will be applicable to the individual offenders, and there are a lot of factors that the judges has to consider. I count probably maybe 15 or 16. I'm not sure, but this is the features of the new guideline. The judges needs to consider offenders' culpability, motive and purpose, etc., etc. But there's also an uncertain terms in terms of the factors. One of which is the society perceptions of law and justice. So this ambiguity would bring a lot of questions in terms of how the judges should interpret the perceptions of law and justice in certain societies. And there's also a redundancy with the factors itself and the formulations of the offenses. If I'm not mistaken, the factors of premeditated or not is also a part of the offense itself. So it's not reasonable to add it as a factors in sentencing while you already consider such elements of offense in the sentencing process itself. So this is the new features of our criminal law in the next 3 years. But interestingly, both for the individual offenders and later I will explain about the legal entity or corporations factors of sentencing. The Indonesian Criminal Code will not give any sort of like punishment for the judges if they're not if they will not follow the guidelines itself. So if we compare with the current Indonesia criminal procedure law, it is similar with what we have in Article 271 in the KUHAP, that in terms of judge's decision in imposing punishment to the offenders, you have to have these items. So these features trying to replicate the KUHAP, but there is no actual incentive or punishment if the judges consider these items in their decisions. Even though it's mandatory, but there is the Indonesian Criminal Code just stop regulating at that point, and it will raise a lot of questions regarding the practical aspect of the guideline itself. The other one, we have also a judicial pardon. So as you know, the judicial pardon under Article 52, paragraph 2, sorry, 54, paragraph 2, is also replicating what the Dutch have at the moment. So there is a possibility for the judges to not to impose any punishment to the offenders, even though they are convicted of committing the crimes itself. The Indonesian Criminal Code also give sort of like explanation that this particular feature will only applicable in less serious crime. But what considered the less serious crime, it doesn't say so. So it's quite open to interpretations, and it needs to be regulated using technical regulations, like I said earlier. And this one for legal entity. So they sort of like make it separate sections from the sentencing itself. So if the corporations convicted of committing of crime, you have to consider a lot of things, level of harm, and then the involvement of directors, and then whether or not this corporation has committed the crimes for several times, and etc. etc. So this is the newest guideline in the brand new Indonesia Criminal Code, which will take into effect in 3 years. But what I consider this is different to the one that Milda said about the corruption cases, and then the one that has been implemented in the US and the UK. In this particular guideline, they don't provide any range of punishment. So if we compare to the PERMA of corruption cases, they mention that the judges needs to consider the role of offender and staff, and they sort of like categorize all of the items into one section, and then they sort of like cross-cutting it with the range of punishment, and then the judges could choose what kind of exact time of imprisonment or fine that could be imposed to the offenders. But in here, the RKUHP did not say anything about it. They just said you have to consider these items while you're sentencing somebody, and then no further formulations at any level. The other things, even though it's not regulated under the sections of sentencing guideline, the RKUHP also gives some guidance to the judges if they're facing a lot of confusion in the practice. For instance, Article 57 said that in terms of the judges have 2 options of sentence. So it's either imprisonment or a fine, for instance. The judges should prefer to use the lighter sentence over the heavier one. But the problem remains the same, because the Indonesian Criminal Code also said that this particular feature will depends on the justification of punishment. So even though the Indonesian Criminal Article 57 regulated that the lighter sentence should be preferred over the heavier one, but the judges consider that it won't do much to the justification of the punishment. This article will not be used in the practice. So this is the uncertainty that I'm talking about in the new system. The good thing, they also sort of like give judges a lot of guidance how to impose imprisonment in their cases. For instance, they have to consider if these items appear in their cases, the imprisonment should not be imposed to the offenders. So if the offenders is over 75 years old, a first-time offender and stuff, they won't be imprisoned, at least according to the text. But if you look into details about the items, the factors on Article 70, you will see that there are a lot of questions that needs to be asked. You know, for instance, here. For instance, if the victim has a role in the commission of crimes, the judges shouldn't impose the imprisonment. So this is in a situation. I believe these features is regulated because in a lot of cases, especially in sexual intercourse between juvenile, for instance, there is a lot of hypotheses that the woman persuaded the male offenders to conduct a sexual intercourse. So that's why in these particular cases, the ICC will take these particular items into consideration, not to impose imprisonment. However, such guidance will not be applicable if the cases consist these elements. So if the cases is a crime which was condemned by minimum 5 years imprisonment, or it has mandatory minimum sentence, or considered too dangerous and too harmful for the public, and involving state or economic laws, this guidance will not be applicable to the cases. So even though they have a lot of positive aspect on how to prevent judges to impose imprisonment, but they also give some leeway for them to reverse all the good initiative in the guideline itself. And this and the ICC will not give any explanation on this particular matter. The other one, the other new features is regarding the criminal fine. As you know, everyone that during our current system, by using this current Indonesian Criminal Code, the offender could choose whether or not they will pay fine, or if they will not pay the fine, they will get an imprisonment as a substitute of not paying the fine itself. But this particular ideas is sort of diminished by the ICC. So the idea in the new criminal code is the fine must be paid at any cost. So it's not an alternative punishment. It's just you must pay the fine if you are condemned by certain fines. However, the fine should be paid within certain period that has been regulated by the judge in their decisions, and then the judge has to consider the offender's real income and expenditure. So this is what one of the features that the drafters sort of like proud about the fine, because they have to, you know, they put a mandatory clause to consider the income and expenditure of the offenders. However, and also and it also could be paid in installments. So this is the newest one, the newest features. However, if the fine cannot be paid in this time frame, there is a confiscation and auction of the assets. So this is the real problem, of the new model of criminal fine. So if we refer to the current system and you are broke, or somewhere you don't have any money to pay the fine, you just simply choose imprisonment as a substitute for the punishment. But in the next 3 years, we will face another system that if you are condemned because of committing a crime by a certain amount of fines, you have to pay that amount, and if you're not able to pay the amount, your assets will be confiscated, and the prosecutor could auction the assets. And if it isn't enough compared to the fine that the judges decided to the offender, and the fine itself do not exceed category 2, so it's under 10 million Indonesian rupiahs, it will be substituted by imprisonment or supervision or community service. However, if the fine itself cannot be executed, so the confiscation of auction of assets cannot be executed, and the fine is more than 10 million Indonesian rupiahs, it will be substituted by imprisonment from 1 year until maximum imprisonment for such offense. So the problem remains the same, everybody. If we compare our situation to the narcotics law at the moment, the minimum fine in that particular law is 800 million of Indonesian rupiahs. Imagine if some drug users was arrested by the police, and then they prosecuted in the court, and then the judges itself sort of like decided, aside from the imprisonment, they have to pay fine 800 million Indonesian rupiahs. You must be paid, and then if first of all you will be confiscated, and then you will get the imprisonment. So aside from the imprisonment, you will be broke because of this new system, and it has to be criticized at any level in this academic forum. The other one, there is also a guidance for imposing community service, and this is the items you have to confess first to the judges, and then you will be assessed whether or not you are capable to do some work, and then whether or not the offenders approve of the proposed community services, and they will be assessed of their social history, religion, belief, and political reference, and also ability to pay fine, because community service will always be substituted by fine. So the idea is, if you're not paying the fine, you will be substituted by community service. But if you can pay the fine, your community services will be reduced proportionally to the fine that you have paid to the state. Another one is regarding the death penalty. As Daniel said extensively during the first sessions, we will have a new features of death penalty, as long as the judges saw the offenders show remorse and then hope to be rehabilitated, and then the role of offenders might not be that significant in terms of commission of the crimes. They will get an automatic 10 years of delayed execution. And then there's a lot of legal uncertainty over there. There's also possibility to be commuted, but the hanging clause is that there is no detailed arrangements on how this should be carried out. We could say, for instance, we've been in contact with the Vice Minister of Law and Human Rights during the discussion of the RKUHP, and he publicly acknowledged that we have a lot of guidelines on prison, on fine, on community services, but we don't have any guidance on how the death penalty should be imposed. But during the discussion in the Parliament, they didn't do anything. So as long as the death penalty is existed in Indonesian criminal law, they will be used, I think, especially in drugs cases, because it raised a lot of public sentiments toward drugs. But however, there's a lot of hope that it can be commuted by these 10 years delay executions. And to answer Daniel's questions earlier, is it applicable to the current death rows inmates? Yes. This is one of the intense debates from the government and the Parliament, because once they make it automatic a mechanism in terms of the probational 10 years of probational period, it activated Article 3, Paragraph 7 of Indonesian Criminal Code that said if there is a change in law and the punishment turned into a lighter sentence, it has to be executed immediately to the current inmates. So yes, I also seconded Daniel's opinion that there's a lot of questions, at least on our part, on how these guidelines, the so-called guidelines, will be implemented in the practice. But that's why I think the government's homework is to create a technical regulations, and also to immediately prepare for the criminal procedure law to prepare everything with all of the changes in the new system. I think that's all for me. I'm giving the screen to Mr. Ladito. Thank you all.
Thank you. Please give more applause from Okay, at last, we are already hearing all of the discussion. Now we next to the discussion session, which is there are some question. Please raise your hand. Rise, okay. From the room in the room, we start from this room. Two people. Okay. The first one, the girl first, then the boys, and after this, we will read some question from the chat room. Okay, please first.
Thank you for the opportunity. Let me introduce myself. I am Luhtiti Sari Lituhayu. I am third semester student here. My question is for Mr. Daniel. Okay, I'm actually don't want to ask about the RKUHP one or related to the material, but since you were talking about death penalty, I want to know your opinion about death penalty and maybe a little bit discussion. Is that okay? Okay, in my opinion, death penalty has never been the right answer. Perpetrators are also human. The death penalty also doesn't decrease the number of cases significantly. I'm taking the example of murder cases. Most of the people in society are too focused on how the most severe punishment for the perpetrators until they are forget that there is the parties that harm, which is the victims. Well, the victim's right is also need to be fulfilled. So what do you think about this and what is your opinion? Well, I also want to know about how the death penalty is in Hong Kong. Okay, can I ask more question? One question.
Okay, please, once more. Okay, after all the question, friends. Yeah.
Okay. My second question is for Mrs. Milda. Just like what you have said before, not all jurisdictions do all the steps or phases completely, the guidelines completely. And this is what you evaluate about. I'm actually didn't really understand in detail about how the AI works. But my question is there already an AI program like this in Indonesia to control maybe some government procedures perhaps, or something similar to it? Thank you.
Okay, thank you. And the next question, please.
Thank you. My question is also to Dr. Daniel. I have two questions in particular for Dr. Daniel. The first is talking about the possibility of double punishment or double jeopardy that you previously talked about. For me, I think it's already happening if Article 100 is to be implemented. By the way, a bit of introduction. My name is Abi. I'm a student of international law. Because in consideration, talking about the death row syndrome that you previously mentioned, in several other jurisdictions, death row syndrome, or not knowing when you will be executed, has been claimed as a human rights violation by itself, regardless or separated by the action of killing these convicts. How is it not going to be a double punishment if the death row syndrome itself is already considered as torture? For example, if I may cite, for example, within the European Union, decision by the European Court of Human Rights in 1989, under the case of Swearing versus United Kingdom, specifically mentioning under Article 3 of the European Convention on Human Rights, mentioning that one of the form of torture is that inmates waiting for a death penalty. So that's the first question. The second question is about the paradigm of punishment and rehabilitation. Do you think that this approach of both punishment and rehabilitation is still going to be relevant after the implementation of Article 100? Because I see that whenever a punishment of death penalty is imposed, meaning that the purpose of such punishment is to punish these individuals, meaning that to put them into, to make them pay for what they have committed in their crimes, and in a form of giving them death penalty. But we're still giving them chance to rehabilitate by giving them a 10-year period. So my question is, if rehabilitation is still going to be allowed in this kind of sentencings, what kind of rehabilitation is expected? Because the alternative other than death penalty is they're going to be in prison for the rest of their life. So what kind of rehabilitation that is expected, and whether or not that kind of rehabilitation is going to be well observed later on? Thank you.
Okay, thank you. Two questions from two people, which from Mas Abi and Mbak Sari to Daniel and Bumilda first. Okay, Daniel, time's yours, please.
Okay, let me respond to Abi, is it? Sari first, right? Let me respond to Sari. Thank you for your questions. Both of the sets of questions are excellent. Very impressed with your questions. Look, my personal opinion on this is that I'm an abolitionist, but my personal opinion is not relevant to Indonesia's debate, because it must be Indonesian people themselves who come to a decision on the death penalty. It's not, it's not for people like me, for foreigners to impose our views on the debate in the House of Representatives. Having said that, clearly what we see with the draft is an attempt to balance different positions, and this is not new. Okay, Professor Muladi, the former Justice Minister, mentioned this when I met him, and the original implementation, or the decision to impose a 10-year probation period, was designed to play off both sides of that debate. Okay, there are retentionists in Indonesian society, and there are abolitionists. And Muladi's argument was that we need to balance both of these views and to try to find a compromise between them. So this is the result. Okay, the result is, formally speaking, to retain the death penalty in law, but practically speaking, to make it very difficult to implement. And when taken to its extreme, you could even imagine Indonesia becoming what we call a de facto abolitionist country. That is the type of country that passes death sentences, but does not execute death sentences. So this is what Muladi meant by retaining the death penalty in law, but imposing the probation period such as to incentivize rehabilitation, and also to make it more difficult to execute. Your second question about Hong Kong. Okay, Hong Kong abolished the death penalty in 1993. In the lead up to the handover from the UK to the People's Republic of China, there was a lot of public anxiety about the Chinese government taking over the running of Hong Kong. And in particular, this stemmed from the 1989 Tiananmen Square incident or massacre. And so the Hong Kong public was very concerned that the same kind of thing could happen in Hong Kong, whether in an extrajudicial way on the streets, or whether it would happen judicially through the imposition of the death penalty. So one of the things they did in that period between 1989 and 1997 was pass a number of laws that would make it more difficult for anyone who came into power after 1997 to impose repressive policies, authoritarian policies. One of them was the imposition, well, the drafting of a Bill of Rights for Hong Kong. In 1991, the Bill of Rights Ordinance was passed. And another major development was the abolition of the death penalty. So there is no more death penalty in Hong Kong. I'll add that even before that, there were no executions in Hong Kong right back to 1966. And the reason that date is significant is because, remember, Hong Kong was a British colony. And 1966 was the last, I think it was 1966 or 65, was the last year in which the death sentence was carried out in the United Kingdom. So in this period, 30 or so years, 27 years, there were death sentences passed in Hong Kong, but they were always commuted through gracie. But in 1997, it was important to get rid of the penalty altogether. Okay, not to rely upon gracie, but to actually stop death sentences being issued. So we don't see the death penalty in Hong Kong. And interestingly, Hong Kong in this sense is a kind of an abolitionist island within a region where most countries retain the death penalty. China obviously has the death penalty. Taiwan has the death penalty. Vietnam has the death penalty. So all of the surrounding countries, Japan, Korea, they all have the death penalty, whereas Hong Kong and Macau don't have the death penalty. Your question. So the double punishment, that's exactly right. And I think there's no avoiding that the fact that one of the significant downsides of this approach, although it will make it more difficult for the Attorney General to execute or to take the decision to execute prisoners, is that it necessarily imposes a double punishment. Okay, you have the time spent, you have two punishments. One is the imprisonment and one is the execution at the end of the imprisonment. I suppose though, I don't know empirically how this will work out, but at least with this arrangement, Article 100, the prisoner has some certainty about what criteria there are to meet. Okay, that is the rehabilitation and the good attitude. Okay, commendable attitude. And secondly, the prisoner knows when that decision will be taken, which is exactly 10 years after the death sentence is first handed down. Okay, so I suppose it's not the worst example of double punishment or the death row syndrome, but certainly any uncertainty as to how long you will live, okay, contributes to this psychological problem. So the drafters knew this, but their aim was to balance these considerations: the retentionist segment of Indonesian society and the retentionist segment of the DPR, right, and the abolitionist equivalent. Okay, your second question was about the purpose of punishment. This is very interesting, I think, and if all death sentences or a majority of death sentences carry with them the probation period, it does seem to change the purpose of punishment. You're right. It seems to greatly incentivize rehabilitation, although you could argue that there is always, even with the current system or the previous system, there is always the possibility of gracie. Okay, so this actually has already changed the purpose of punishment. A prisoner who behaves very well on death row in Indonesia can already receive gracie, and there are historical precedents for prisoners to have their sentences reduced by the president. So there was already rehabilitation built in. So if your question is, what now is the punishment purpose of the death penalty? It's not retribution anymore. I suppose the answer is that it's rehabilitation, but it's also deterrence. Okay, you didn't mention deterrence anymore. And the argument, okay, the argument would be that the suspended death sentence is meant to deter more than a life sentence. Okay, this is the argument. This is called marginal deterrence. In practice, the studies don't bear this out. This is the problem. In practice, the studies show that that the death sentence, or even the threat of the death sentence here, does not convince people to change their behavior any more than life imprisonment. And the reason is simple, that life imprisonment is still an extremely severe punishment. So you're not going to sort of weigh the costs and benefits of acting and think, well, am I going to get death or am I going to live the rest of my life in prison? Already living the rest of your life in prison is extremely severe punishment. So yes, it does change the nature of the justifications for punishment. Incapacitation, well, that's the other one we didn't mention. I suppose, you know, the death penalty incapacitates by if you kill the prisoner, then he can no longer offend. Okay, whether that's in prison or whether that's in the community. In this context, by keeping the prisoner detained for at least 10 years before a decision is made as to the death or life imprisonment, at least in the community, it still serves an incapacitated function. Okay, because you cannot offend in the community if you're in prison. You know, this is the logic. It's not retribution, it's not deterrence, it's not rehabilitation, but it's actually the prevention of crime in the future physically. But thank you for all of your questions. Very interesting.
Okay, thank you, Daniel. And next, Bumilda, maybe, please.
Thank you, Pak Ladito, and thank you for Sari for the question, very interesting one. If you ask whether there is any regulation that use the AI in the sentencing, as far as I'm concerned, if we compare to other countries in Asian countries, it is actually only Malaysia, but it's not a federal state. It's only some parts of the jurisdiction that already apply artificial intelligence for the sentencing process. But again, there is also pros and cons to this kind of arrangement, because they don't want to use that kind of mathematical process in order to impose sentencing outcomes. So in that Malaysian regulation, they say that it is only a suggestion. Whether or not the judges want to use that suggestion, it's up to the judges. And this is also what we want to say in our paper. The most interesting part is that when we distribute this flyer, and then when the participants read the title of our presentation, and then I got lots of questions, like, for example, why do you want to replace the judges? Why do you want to use robots to impose the sentencing outcomes? So that's the main thing. We don't want to replace our judges. This is only like a small part before the sentencing process is taken. There will be like suggestions, okay, if the categories of the corruption, the state financial loss is 200 billion rupiahs, and then how we end up with the sentencing outcomes, which is more consistent. That is the only thing that we want to argue in this paper. And I also want to go to Pak Leopold's question. Is that okay, Pak Ladito?
Oh, wait, maybe I will open the next session first.
Oh, okay. Thank you.
Okay. Next, we will the next session from Zoom. Maybe is there anyone will ask directly from all the speakers? Please raise the hand, maybe. No? Okay. Maybe I will continue to the chat room question. Oh, yes.
Can I will ask a question actually of Dr. Milda and Dr. Amin. There is quite a lot of literature already on AI as a tool to assist people like judges, as you mentioned, and as a tool to assist parole boards, okay, on the release of prisoners. Have we seen anywhere in the world AI used as a tool to help prosecutors, okay, decide which cases to prosecute, and if they do, which charges to bring?
Amin, do you want to answer that?
Yeah, can you hear me, everyone? Yeah, so I don't have any on the top of my mind because I read recently around 30 different use cases, but there was this specific case about whether to help the prosecutors to whether pursue a case or not based on the available evidence and the fact that it would, help them to be more efficient. I'm not sure if it was one of those projects that they're planning for the future, or it's being currently applied. I can take a look and just drop you an email about it. But it's a good point that, yeah, there's not much on that side. It's mostly about making the process more efficient for the court and for the parties, which again, it goes back to making things more efficient for the court. So yeah, there is not much focus apparently on prosecutors and making their life easier.
Yeah, thank you. Okay, there are a lot of questions in the chat room. Maybe I will give to Dr. Amrin and Bumilda. First from Pak Leopold, and the second is from Pak Teng Junaidi. The question is about if 62% of the case related with drugs, would you think applying artificial intelligence in sentencing in this crime more feasible than other crimes? Or and the second is during the trial, new factor might appear. However, this factor is not a part existing element of the offense and may not calculate by the AI. How the system respond it? And from Pak Teng Junaidi for Dr. Armin about the formula of Bentham's 13 sentencing guidelines. What do you think about AI? And enough from Dr. Amrin and Bumilda. Maybe it's your time.
So I'll respond to Pak Leopold's question first. He is asking whether or not this kind of data set can be used for drugs offenses, if I'm not mistaken. So the criteria, Pak Eki already gives some suggestion. It's not actually sentencing guideline. I agree with you. It's not actually guidelines. It's actually criteria. So the criteria that they used in the PERMA is actually based on several categories, as I mentioned before. The judges may consider about the first one is the financial state loss, and then the fault aspect, the impact aspect, benefit, and then other circumstances such as aggravating and mitigating factors. The main point that we want to highlight is that we need to understand about the severity of the crime first, and then we apply that into other crime or offenses, which is it's similar. If in the corruption cases, we use the state financial loss as one of the elements of the severity of crime, then if we want to apply that guidelines into different types of offenses, like for example, in the drugs trafficking or drugs offenses, then we need to evaluate, or we need to analyze what is the severity of the crime. Like for example, we can use the criteria of how much the use of the drugs in each offense. That's like only one of the elements. But then of course, we need to read all of the verdicts and then need to set up a criteria based on what the previous study or what previous literature review mentioned about that. We cannot just come up with, okay, these are the criteria and that we want judges to consider this. But we need to look at the previous study and then what are the sentencing factors, what are the recommendation or consideration that the judges may consider to this kind of offenses. I think that's my quick response to Pak Leo. Thank you.
Okay, maybe Dr. Armin, if you do want to adding something.
Yeah, so about that drug offenses, I have absolutely no idea. So whatever I know about Indonesian criminal justice system is what Milda has told me. And yeah, so I don't have anything to say about that. But about the fact that, for instance, there is new evidence about motives, I'm a bit unclear about the question. So if there is new evidence about motives, why shouldn't we recalculate the whole thing? Why shouldn't we give the whole thing again back to AI from the very beginning and see, whether it's being consistent with what the judge has selected or not? And this is at the sentencing phase. And if I understand the system correctly, it's just at the very end of this whole, trial that the judge is making the sentence. So that's where things end. So at the very end, if there's new evidence and if it's admissible at that part of the process, then they can just put it in the, as part of the judgment and, run the AI one more time to see how things are being different. And there was another question about the minority report, which I found it to be very interesting, but I'm very unclear about it. So Compass, yes, it supposedly acts like minority report. And to...
Jadi enggak, aku soalnya belum beli tiket. Ini mau tiket deh kalau mau tutup.
Was that a question for me or not? Or could someone clarify, because I couldn't understand anything? Okay, so I'll continue. Yeah, so yeah, Minority Report, it's a movie about like a system that can predict offenses, and so it's of course a science fiction. And Compass is supposedly imitating that system, but of course it's far from being that close in terms of accuracy. So yeah, the idea is similar, but in reality, predictions are very difficult. You would never know if you find this person to be very dangerous and there is a high risk of reoffending. You want to keep them for a longer period of time in prison. How would you know whether they would have committed an offense or not? So yeah, there's a problem there. And then part of the question asked the problem of the precog versus our legal normativism. I didn't get that part, honestly. The retributive sentencing purpose theory is asking punish only under guilty mind and the damages the crime caused. This formula is also Bentham's 13 sentencing guidelines. So what do you think? I can't understand the question, unfortunately.
Okay, thank you, Dr. Armin. The next to Mas Anugrah Rizky Akbari. There are two questions there. The first from Pak Teng Junaidi about, has your research includes double track sentencing system, or in Netherlands is called dualistic sentencing system, where it was implemented in our old KUHP and even in the Netherlands BVS. And the second from Pak Ahmad Rifai about after replacing the criminal code, Indonesian new criminal code, it's clear stiff freedom of expression, especially critique for the government. Doesn't change our democratic states. Please your statement. Okay, Pak Anugrah Rizky, time's yours.
Thank you, Mas Larito. I just realized right now that you said earlier that the Indonesians' newest criminal code will sort of like adapt to the double track system of punishment. But interestingly, within this very new draft, there is no guidelines on how the treatment should be imposed. They all focus on the sentence itself. Whether or not the death penalty should be implemented, and then how to impose the imprisonment, fine, or community service and supervision. But not a single one regulated the treatment itself. So how the judges should consider rehabilitations, for instance, and then how the corporations should be supervision. Supervise. For instance, there's no regulation at all regarding the treatment itself. And for the second one, how the criminal code will change our state of democratic sphere in Indonesia. So yes, there is a problematic, very problematic articles in terms of freedom of expression. But then I won't defend any government's claims, and it's not ideal as well. The ideal is to abolish all of these stipulations on expression and then privacy and everything. But then we have to push at the very edge of of its formulation, that even though there is an article regarding defamation of president, vice president, and the state institutions, and also the government itself, we will have to acknowledge that these offenses is created under a complaint-based offense. So what we have to do, we have a lot of options, of course. It's still 3 years of the transitional period. If we're learning from the Netherlands, when they sort of like changed their own criminal code from the Code Penal in 1996. They have 5 years of transitional period. So during those 5 years, the government sort of like review all of the articles. They even deleted some articles that they consider problematic. So in these 3 years, it's crucial for us academics and practitioners to give continuous review, continuous insight inputs to the government, so the preparations of the new system could be as smooth as possible. And if I agree with you that the criminalization that took place in terms of defamations is not going into positive directions. They did not give any explanation on what kind of conduct that considered as defamation. There were a lot of inputs from civil society organization that the government should change the element of crime from defame to delivering false accusation towards governments or presidents or state institutions. In that case, the implementations of such particular articles will be limited to only a much more clear conduct rather than the defamation itself. And in the newest development of defamation law, a lot of countries won't use criminal law mechanism to deal with this kind of offense. They either drop the articles or they push it through the civil mechanism in their own legal system. I think that's my answer to both questions, Mas Madito.
Okay, thank you, Pak Anugrah Rizky. And last question for Daniel from Pak Teng Junaidi. As abolitionists, can you still accept death penalties for crimes against humanities? Please.
Okay, if you're going to be a death penalty abolitionist, it's especially these sorts of crimes that you need to oppose the death penalty for. So there's no point, I think, making exceptions if you feel that the death penalty is wrong from a human rights perspective, is wrong from a moral perspective. And it's especially these kinds of cases, and controversially, these kinds of cases, say terrorism cases, when many people die from terrorism attacks, that you need to double down on your advocacy against the death sentence, because it won't work, and you will be labeled a hypocrite if you pick and choose your cases for which the death penalty should be imposed. So in summary, yes, I am opposed to the death sentence as a matter of principle, okay, rather than as a deterrent issue, rather than as a financial issue or any practical. I personally am opposed on a matter of principle, which means you need to oppose it for all types of crimes, whether it's a drug offense, whether it's a murder case, or whether it's a crime of terrorism that kills a lot of people. You have to have a consistent moral stance.
Okay, thank you, Daniel, for the answer, and I think that's enough time. And thanks for the all question. Thanks from the speakers. Thanks for Dr. Daniel, Dr. Armin, Dr. Milda, and Anugrah Rizky. And thanks for the all participants which is in Zoom or live in that room. Okay, thanks for all. Then see you in the next seminar. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon.